And okay, bueno, I'm going to talk a little bit in Spanish. Muchas gracias por estar aquí. Esta es una nueva sesión del seminario Poder Constituyente y Reforma Constitucional. Estamos ahora con dos profesores de la Universidad de Dundee y Glasgow, la profesora Ashley Oselik-Olkey y el profesor Tariq Olkey, que son profesores que originalmente son de Turquía, pero hace más de 8 años están viviendo en Escocia y han hecho ya su doctorado, están haciendo su postdoctorado. Ashley está trabajando en la Universidad de Glasgow y Tariq está trabajando en la Universidad de Dundee. Voy a presentarles un poquito antes de comenzar en español y después vamos a desarrollar una sesión en inglés, pero vamos a traducir un poco para que ustedes, los que pues, puedan hablar en inglés, pero también los que no lo puedan hacer también estén aquí pendientes. Ashley is a postdoctoral researcher in international law at the University of Glasgow, where she's also the academic coordinator of the Glasgow Center for International Law and Security. She works in the fields of public international law, international human rights, international criminal law, and comparative constitutional law, with a particular interest in peacemaking, no-state armed groups, self-determination, transitional justice, and post-conflict constitutional making. She holds law degrees from Glasgow, Cambridge, and Bilkent in Turkey. Entonces ella es Ashley Oselik es una profesora que está haciendo sus estudios postdoctorales e investigaciones en Derecho Internacional en la Universidad de Glasgow, donde ella también es coordinadora del Centro Internacional de Derecho Internacional y Seguridad de Glasgow. Ella también trabaja en los campos de el derecho internacional público, en derecho internacional de los derechos humanos, en derecho penal internacional y en derecho constitucional comparado, con un interés particular en procesos de paz y en lo que no son grupos, digamos que armados no estatales, autodeterminación, justicia transicional y en el tema que nos convoca hoy, que es los procesos, digamos, de elaboración constitucional después del conflicto. Ella tiene digamos, sus títulos vienen de la Universidad de Glasgow, de Cambridge y de la Universidad de Bilkent en Turquía. Entonces, bienvenida. Welcome, Ashley. Manu también le interesa todo lo que tiene que ver con seguridad, así que va a estar encantada aquí en este panel hasta donde nos pueda acompañar. Professor Tariq Olkey is a lecturer in law at the University of Dundee, where he teaches UK public law and comparative constitutional law. He specializes in constitutional law and legal theory, and his main research interests lie in comparative constitutional law, constitutional theory, and natural law theories. Es el profesor Tariq Olkey, que es profesor, digamos, de la Universidad de Dundee, lector, donde él imparte las clases de Derecho Público de la Gran Bretaña y Derecho Constitucional Comparado, y se ha especializado en Derecho Constitucional, en teoría jurídica, y sus principales intereses de investigación están en Derecho Constitucional Comparado, Teoría Constitucional y Teorías del Derecho Natural. Luego tenemos como comentarista el profesor Fabio Estrada. Lo voy a decir en inglés. I'm going to speak in English also. He's a lawyer graduated at the University of Colombia, holder of a specialization in public law from the same institution, master degree in international law at the University de los Andes, professional especializado, grado 33, bueno, in the first section of the Council of State in Colombia, and research professor of constitutional law at the University of Colombia. Profesor Fabio, bueno, es profesor de la Universidad Externada de Colombia, el Departamento de Derecho Constitucional, que ha hecho su especialización también en el externado, su máster en la Universidad de los Andes, con un tema de qué trabajó Fabio, el tema en la Universidad de los Andes.
El principio de proporcionalidad de la sanción penal en el acuerdo de paz y el estándar internacional de proporcionalidad de las sanciones.
Could you please tell us in English what was your topic in the master degree that you did in Los Andes University?
The proportionality principles of the penal sanction in the peace agreement submitted in Colombia between the government of Colombia and the FARC-EP.
And you haven't published that
No, I haven't published yet this document.
Okay, probably if you have some conversation with
have
Tariq and Ashley will.
Other papers regarding this topic.
And also, Fabio did a very important book related with constitutional reform, that the presidential powers in and the constitutional reform, no?
Yes.
That is one of my favorite books. I hold here your book. I direct his thesis, and it was a pleasure to direct his thesis from the law degree. Thank you very much, the three of you. We are going to do a conversation about one paper that you already published in Icon Journal. That is a very important journal in comparative constitutional law, and is the same title of the presentation, Unconstitutional Change Rooted in Peace Agreements. No, the title probably is longer, and it's already published in Icon, no, in the 2020 number on Constitutional Change Rooted in Peace Agreements. Issue 4, December 2020. That is the paper that both Ashley and Tariq published. So congratulations for this paper, and we are going to talk about this paper because this paper is very important also in comparative constitutional law. They compare the Colombian case with the other transitional justice in the world, really, for example, Iraq, and also related with constitutional making and constitutional reform. So the both topics, transitional justice and constitutional reform and constitutional making. So you have 15, 20 minutes, no, 40 minutes, whatever you want, no, 30 minutes or 20 minutes to talk about your paper, each of you. Thank you very much for being here. So it's a pleasure.
Thank you very much, Gonzalo, for the kind words, for the invitation. It's an absolute pleasure to be here today. As you mentioned, this paper has already been published in the International Journal of Constitutional Law, but it's also part of an ongoing project that Tariq and I are working on constitutional change and peace processes. So we really appreciate the opportunity today to talk to you about it, to receive feedback, and especially to learn more about the Colombian context. So I'm looking forward to also hearing Fabio's comments, and thanks very much to him as well for agreeing to join us today. I'll start talking about our paper and then hand over to Tariq in 10 minutes, hopefully. I wanted to start with a bit of context and wanted to tell you about the general idea behind this paper. As you mentioned, this is quite an important issue for comparative constitutional law. It comes up quite often in transitional contexts, in post-conflict contexts. We specifically focus on internal armed conflicts, on civil wars, because this is the predominant type of conflict that we see around the world today. And some 1,000 peace agreements have been concluded to end these types of conflicts in the past 3 decades. So this is a significant field of practice where international law and constitutional law considerations come together. And that's also the general idea behind our paper, to bring together these two disciplines and see how they interact with each other. More than 100 of these 1,000 peace agreements include constitutional change provisions. This is often required because ending these conflicts require fundamental changes to existing constitutions. Sometimes constitutional change is needed to introduce human rights guarantees. Sometimes it's needed to implement land reform, for example, or sometimes it's needed to make the existing legal and political order more inclusive, where the exclusionary structures are among the root causes of the conflict. Even though constitutional change might be required, it is not straightforward because, especially when it is done within an existing constitution, these agreements face the unconstitutionality challenge, because often the reform promised in an agreement is in tension with the existing constitution. That is why an amendment is required in the first place. So we, in this paper, try to highlight this problem, the problem of unconstitutionality, because there is a lot of literature on new constitutions in post-conflict settings, but the issue of constitutional amendment is less explored. And after exploring this unconstitutionality challenge, we also identify 3 strategies that can be employed to overcome this challenge. And we talk about the limitations of these strategies as well. So before talking about the unconstitutionality challenge, it's important to understand the different modalities of constitutional change, because then we see in which settings the constitutionality challenge, the unconstitutionality challenge, is likelier to arise. When we looked at these more than 100 peace agreements that promise constitutional change, we saw that there are 3 main types of constitutional reform. In the first modality, we have the peace agreements that contain the final constitution. There are only a few examples of this, but for example, the Dayton Peace Agreement that was concluded to end the conflict in Bosnia is a very good example. That agreement included the Constitution of Bosnia as an annex. So the new constitution was already there. There was no question about its unconstitutionality because it's a new constitution. And there was no need for a constitution making process because it was already agreed as part of the negotiations. The Iraqi constitution is another example. Here, there was no peace agreement, but the constitution itself functioned as a peace agreement. And then we have the second type of constitutional change provisions in peace agreements. These foresee that a new constitution will be made after the agreement is adopted. And then the agreement sets a procedural framework, for example, a timeline, or about which actors are going to be involved in this process, and also a substantive framework in terms of which substantive constitutional principles like democracy, human rights, liberalism, etc., are going to be included in this post-conflict constitution. This was done in South Africa, in Rwanda, in Burundi, for example. The final type of constitutional change, which is what we focus in this paper and which is the more relevant modality to Colombia, is the promise of constitutional amendment in a peace agreement. So in this case, we see the unconstitutionality challenge arise because the amendment is made to an existing constitution. There is no new constitution to justify any radical change to the constitution. As I mentioned, this was the case with the 2016 peace agreement between the Colombian government and the FARC, but it was also the case in many other peace agreements. In the paper, we also look at the Philippines more closely, but we see this also in Mali, for example, in Bangladesh, and in other contexts as well. So the unconstitutionality challenge arises against this type of constitutional change. And in the paper, we look at, as I mentioned, 3 strategies that can be useful in overcoming this unconstitutionality challenge. I'll talk about the first one and then hand over to Tarek. So the first one is again familiar to you probably because it was the strategy that the parties tried to adopt in Colombia. So here, peacemaking parties to a peace agreement, try to attribute supraconstitutional or international legal status to peace agreements. Why do they do this? Because they want to elevate the peace agreement above the constitution and protect it from constitutional review and from future legislative challenges. In some cases, in very few cases, these are extreme examples, the peace agreement might contain provisions that would automatically replace the constitution. In Rwanda, this was the case, for example. Some of the provisions of the constitution were automatically replaced by the peace agreement. So there was no extra constitutional amendment. It was an extra constitutional change. But as I said, this was a very extreme example, and we see this in only very few peace agreements. What is more common is trying to attach international legal status to peace agreements. And this strategy is prone to failure for a number of reasons. First of all, the legal status of peace agreements with non-state armed groups in international law is contested. In mainstream accounts of international law, it is not accepted that non-state armed groups have treaty-making capacity. So in Colombia, for example, the 2016 peace agreement was signed as a special agreement under international humanitarian law with reference to the Geneva Conventions to give international standing to the agreement. As I said, this was prone to failure and failed in some ways because the original version of the agreement provided that the agreement would be part of the constitutional bloc. And this is precisely because the parties wanted to give constitutional status to the agreement and protect it from future challenges. In addition to the weakness of the argument that peace agreements can be international legal agreements, there was a further weakness in this case because the parties tried to refer to the agreement as a special agreement, but the agreement went significantly beyond the scope of special agreements under international humanitarian law, because these agreements, special agreements, are meant to bring international humanitarian law or human rights law into effect between conflict parties. They're not meant to address constitutional issues like land reform or transitional justice or political participation. So to the extent that the Colombian agreement went beyond humanitarian law, I don't think it can be accepted as a special agreement. So that was a further weakness of the strategy. And as you'll know, the Constitutional Court ruled that the agreement can't be automatically part of the Constitution. And the agreement was rejected at the plebiscite. So the revised agreement removed the reference to the constitutional bloc and only accepted the agreement as a parameter for the interpretation of the implementing laws. So there was a, the parties departed from the initial more radical approach. And this issue, as I mentioned, comes up in other jurisdictions as well. In the Philippines, for example, there was a discussion about whether a peace agreement that was signed between the government and the Moro armed group, a Muslim armed group, Islamic armed group in the Philippines. This agreement was signed in 2008, and it was discussed whether this agreement was an international agreement, and the court ruled that it can't be an international agreement or binding under international law. And what's interesting is that in this decision, the court also said that promising a constitutional amendment in a peace agreement is in and of itself a violation of the Constitution, regardless of the legal status of the agreement, because this is a promise of an amendment that doesn't comply with the procedures provided in a constitution. So we see a story that is similar to the Colombian story here. In the 2008 agreement, the language used was quite strong. The agreement included a guarantee to amend the constitution, But after the court's decision, a new agreement was negotiated, and in 2014 it was adopted. And this included softer language, and it didn't guarantee an amendment. It only provided that there's a right to seek constitutional change in constitutionally compliant ways. So the strategy, the first strategy that we looked at, attributing supraconstitutional or international legal status to peace agreements, is quite limited in its effectiveness. Over to you, Tarek.
Okay, so another possible strategy to overcome this constitutionality challenge for constitutional amendments rooted in peace agreements may be to make reference to international law. The constitutionality of the constitutional amendments would normally be assessed by courts with reference to domestic fundamental constitutional principles, and under the Unconstitutional Constitutional Amendments Doctrine, some courts indeed exercise such review and invalidate sometimes procedurally properly made constitutional amendments. Here we look at whether it's possible and desirable to assess the constitutionality of constitutional amendments that are rooted in peace agreements with reference not to domestic fundamental constitutional principles, but with reference to international law. It's important to note here that whether recourse to international law can be made in assessing an unconstitutionality challenge will depend on the hierarchy between international law and the constitutional provisions in a particular jurisdiction. Although there's some scholarship suggesting that international law places certain constraints on constitutional amendments, we think it's doubtful that this would be the case in the absence of an express or implicit reference to this effect from within the domestic constitutional order, not least as the idea of an unconstitutional constitutional amendment itself is a contentiously debated topic in constitutional law scholarship and not accepted in every jurisdiction. In Colombia, the Constitutional Court reviewed a constitutional amendment made in 2013, which added a transitional article to the Colombian constitution, and provided the amendment provided for differential treatment of the perpetrators of conflict-related crimes and partially departed from the relevant criminal justice provisions in Colombian law. In its decision, Sentencia C579/13, the Constitutional Court resorted to international law in upholding the constitutionality of the transitional justice system that was envisaged by the parties engaged in peace negotiations. Specifically, the Constitutional Court ruled that a state can grant amnesty to crimes other than international crimes as per Article 6, Paragraph 5 of the Second Additional Protocol of the Geneva Conventions, and that it can lawfully limit criminal prosecution only to international crimes and design some non-judicial mechanisms for other crimes. The court therefore allowed the accommodation of the peace agreement-based constitutional amendment through recourse to international law. I think we're one slide ahead of what I'm doing. No, ahead, yeah, just before that. Yeah, thanks. So this was what the Colombian Constitutional Court did in that specific decision, and in subsequent some of its subsequent decisions, was possible because of the constitutional block doctrine that Asli mentioned as well, whereby the court identifies certain extra constitutional norms, some norms that are not contained in the text of the Colombian Constitution, as reference norms in exercising constitutional review. The Colombian Constitutional Court adopts this doctrine to incorporate international law into Colombian domestic constitutional law, into the constitutional block. And coupled with the constitutional replacement doctrine, which is the Colombian Constitutional Court's version of the Unconstitutional Constitutional Amendments doctrine. This provides for the judicially enforceable subjection of constitutional amendments to international law. We think this is a good example that even where recourse to international law has been made by a court, we see a clear and established domestic constitutional framework that allows such accommodation. The Colombian Constitutional Court was able to refer to international law within the context of transitional justice, but international law can be silent or underspecified in certain other areas that are governed by the process or dealt with during the process of transitional justice, and therefore can offer little guidance to assess the legality of proposed constitutional amendments. So on to transitionalist judicial review, which is the third strategy that we talk about in our paper. Depending on the domestic constitutional law in a given jurisdiction, peace agreements or constitutional changes rooted in peace agreements may be brought before constitutional courts, may be challenged before constitutional courts. And in such cases, another way to overcome such constitutionality challenges we identify is for constitutional courts to adopt a transitionalist jurisprudence. This is likely to arise in countries where courts have strong judicial review powers. We can see the leniency of a constitutional court to peacemaking in its interpretation of the norms of the existing constitution in a way that tries to accommodate the provisions or the promises of a peace agreement. For example, again, the Colombian Constitutional Court has engaged in such practice where it's modified its constitutional replacement doctrine in the face of a peace process. According to the constitutional replacement doctrine, the court reviews constitutional amendments to make sure that the constitutional amendment at hand is merely an amendment to the existing constitution, and it's not something that amounts to the replacement of the constitution with a new one by changing the fundamental principles of the existing constitution. However, when the court reviewed constitutional amendments that incorporated the transitional requirements of the peace agreement in Colombia, it devised a way to apply the constitutional replacement doctrine in a way that accommodated the peace agreement within the existing constitutional order. There, the court developed a test to balance the principles of the constitution, the existing principles of the constitution that we find in the already established constitutional bloc, and the constitutional amendments' underlying principle of the search for peace and reconciliation. So we see the conceptualization of the right to peace, or the search for peace and reconciliation, as a different yet relevant fundamental principle. In this way, the court moderated its constitutional replacement review when faced with a peace agreement in that transitional justice context. Later on, the court also accorded the peace agreement a normative character and regarded it as a parameter of constitutional interpretation, and this was something that was suggested in the peace agreement itself, whilst also noting that the peace agreement must always be interpreted in a way that is harmonized with the principles of the constitution, as had been suggested by the peace agreement. So while such transitionalist judicial review, adopting such transitionalist judicial review does promise to ensure and maintain a dialogue between a hard-achieved peace agreement and the principles and institutions of an existing constitution, we also identify certain limitations. First of all, the success of such an approach is highly dependent on the constitutional context. In order to be able to engage in such practice, a constitutional court must have the constitutional competence, the legal authority, and also most of the time a strong public standing for its jurisprudence to hold. For instance, the strong constitutional and political role of the Colombian Constitutional Court in the Colombian constitutional order, we think, allowed it the institutional margin to engage in transitionalist judicial review, which may not be possible in some other jurisdictions where courts may not be regarded as highly. Secondly, constitutional courts can be politically aligned with the government or with the status quo in transitional countries, and it might be unrealistic to expect courts to fulfill the role of incorporating peace agreements into the constitutional order. In transitional societies, constitutional courts may be as polarized as other legal and political institutions. A transitionalist judicial review of constitutional changes rooted in peace agreements may not be therefore realistic or even desirable. And also in many jurisdictions, courts would face constitutional obstacles in reviewing constitutional amendments. We see comparative constitutional practice shows that the doctrine of unconstitutional constitutional amendments, whereby constitutional amendments are judicially reviewed with a view for them to be invalidated, possibly, is a controversial, can be a controversial judicial practice, and it's certainly not accepted everywhere. Thirdly, constitutional courts can be disinclined to take political risks in a transitional setting, especially as such adjudication could affect not only the interpretation of a peace agreement or constitutional principles, but more substantial legitimacy concerns about the whole peace process. In certain contexts, achievement of peace may rely on the success of the proposed constitutional reforms, and constitutional courts may be unwilling to play such a major and potentially institutionally risky political role in the process. And lastly, peace agreements can envisage constitutional amendments that clearly go against the fundamental principles of a constitution. In such cases, constitutional courts are unlikely to take on the challenge of overcoming the unconstitutionality challenge. And this is from a legalistic perspective. It is very difficult for constitutional courts generally to authorize or ignore outright violations of the Constitution, as ultimately their authority derives from the existing Constitution in the first place. So to conclude, our first aim in this paper has been to draw attention to the challenge of unconstitutionality, or the challenge of constitutionality that may arise when peace agreements promise amendments to an existing constitution. The literature predominantly focuses on constitution making rather than constitutional amendment in transitional contexts, as Asli explained. But it is not always possible or necessary to make a new constitution for peacemaking, and it is important to understand that constitutional amendment presents different challenges than those presented by having a constituent process, a constitution-making process, which results in an entirely new constitution. Secondly, we aim to show that the three potential methods or strategies of shielding peace agreements from constitutionality challenges have their limits. Their success is, we think, largely dependent on constitutional and institutional contexts, and it's difficult to endorse any one method generally to overcome constitutionality challenges. Formal constitutional change is unavoidable in certain transitional contexts, and if parties desire for the constitutional legal promises made in the negotiations and peace agreements to be effective, they need to take the existing constitution and the constitutional order seriously and devise strategies with having regard to these considerations. And that's pretty much all that I have to say.
You're on mute,
You're on
Gonzalo.
mute, Gonzalo.
Thank you very much, both of you. Thank you very much, Ashley. Thank you very much, Tariq, for the wonderful paper and also the wonderful explanation of your paper. I think it's a very good work in comparative constitutional law and brought us very big ideas trying to understand all the challenges related with the constitutional reform and constitutional making process for in transitional justice times. So I'm going to translate a little bit of your talk, not exactly what you talk, but not all that what you explained, but a little bit the main ideas, and then I will let Fabio to make the comments in English, okay?
Yeah, that's great. Yeah, that's actually
Thank
very
you.
kind of you. Thank you.
Ok, voy a hablar un poquito en español. Bueno, no voy a explicar todo lo que ellos dijeron puntualmente, porque pues tomaría mucho tiempo. Y bueno, lo que Tariq y Ashley hicieron en el paper, en el artículo que fue publicado en ICON, tiene como fundamento pues una explicación en derecho constitucional comparado de las reformas constitucionales y los procesos de elaboración constitucional y en justicia, en tiempos de justicia transicional, ¿no? Que este término, como saben ustedes, ha sido utilizado, tal vez Rudy Title, pues lo ha empezado a usar como una forma no solamente de la dictadura a la democracia, sino también después de conflictos armados como el caso colombiano. Entonces ellos nos dijeron que existen al menos 3 tipos de formas de hacer, digamos, reformas constitucionales e incluso constituciones después de procesos de paz o de procesos, digamos, de paz y de justicia transicional. Por ejemplo, la constitución de Irak, ¿no? Que concluyó con una constitución, o la de Borneo, es uno de los tipos, es decir, de procedimientos, concluir una constitución como después de un proceso de paz. Quizás nosotros en la constitución del 91, maybe also with the 1991 constitution, we have the same idea of finish a peace agreement with a new constitution, but it's not only because of the peace agreement with M19 movement. Quizás en los 90, ¿no? Cuando hicimos el proceso de paz con la, digo yo, esto es un comentario y le estoy quitando la palabra a Fabio, hicimos la constitución del 91, pues también se derivó la constitución en parte de un proceso de paz. Entonces ese sería el primer tipo, ¿no? Terminar una constitución después de un proceso de justicia transicional o un proceso de paz, digamos. En el caso de nuevas constituciones que derivan también, digamos, de procesos de paz, ellos hallaron otro tipo y es el de crear procedimientos para hacer una nueva constitución. Y ahí está el caso principalmente de Sudáfrica, ¿no? 1993 a 1996, ellos hicieron una constitución, pero el proceso de paz, los 40 y pico artículos que hicieron como base, la ley fundamental, lo que hizo fue pues establecer el procedimiento y no la nueva constitución. Ese sería el segundo caso, no hacer una nueva constitución, sino un procedimiento para elaborar una nueva constitución. También la constitución de Ruanda y la constitución de Burundi tienen estarían en esa segunda tipología. Y luego pues nos hablan del caso colombiano y luego del caso de las Filipinas, que tenemos que comparar allí también, que son países que utilizaron reformas constitucionales para llevar a cabo la implementación de acuerdos de paz o de justicia transicional a través de reformas constitucionales, como el Acto Legislativo 1 de 2016. Luego llegaron a un segundo tema muy interesante que aquí se discutió, que fue qué pasa con los tratados internacionales sobre derechos humanos y las normas de DIH y las normas supranacionales que acá llamamos, digamos, bloque de constitucionalidad cuando hay procesos de justicia transicional. Y ellos hablaron un poco de, pues que esto, más o menos Tariq dijo que es necesario que exista, digamos, explícitamente una norma que permita, ¿no?, que los digamos, tratados de derecho internacional y derechos humanos, las normas supranacionales, puedan ser un marco también para tener en cuenta en los procesos de paz. Y el caso colombiano, ¿no? Con la discusión, ¿no? Del artículo tercero de los convenios de Ginebra, también es uno de los aspectos a tener en cuenta. ¿Cuál sería entonces el valor jurídico de los acuerdos de paz, si hacen parte del bloque, si no? Eso es otro tema que ellos trataron. Y luego otro tema que trataron, digamos, a grandes rasgos, pues es todo lo que tiene que ver con las cortes, ¿no? Es otro tema grande en esto, y es decir, si se van a hacer reformas constitucionales, como es el caso de Colombia, van a tener que intervenir las cortes constitucionales o tribunales constitucionales y valorar si pues la constitucionalidad, digamos, de las reformas constitucionales derivadas de acuerdos de paz o de justicia transicional. Y ahí vienen, digamos, los aspectos que ellos encontraron interesantes en el caso colombiano, de cómo podrían valorar las cortes constitucionales los acuerdos de paz, y ellos, digamos, hablaron de este punto, ¿no? Y ahí se necesitaría, digamos, tener en cuenta la autonomía de estas cortes, la valoración o los tests que se realizan para tratar de buscar cómo incluso ponderar, que es el tema de Fabio, principios constitucionales, especialmente el caso colombiano, que tiene pues la tesis de la inconstitucionalidad de las reformas constitucionales por sustitución, cuando pues se tendrían que ponderar principios consustanciales, como por ejemplo el derecho de las víctimas o de participación política, y el de la paz. Más o menos, ¿no? Tienen que leer el paper y ver la presentación nuevamente. No tenemos ahora traductor simultáneo. Fueron los puntos que trataron. No es una traducción, digamos, totalmente fiel a lo que ellos expusieron, pero pues son algunos de los puntos que ellos trataron en el paper y también en la explicación. So I'm going to let Fabio to do the comments. If you want to talk a little bit later about your comments in Spanish, also will be helpful for the people who cannot understand English. So you can do your presentation in English, Fabio, and then a little bit explain your own presentation in Spanish, okay?
Perfect. Well, good morning, everyone in Colombia. Good afternoon in Scotland. First of all, I want to thank Gonzalo Ramirez for inviting me to this seminar. In my view, it's a privilege to be here with all of you, especially with Professors Tariq Olkay and Osalik Olkay, who have a great experience in constituent power, constitutional reforms, and peace agreements around the world. Well, regarding the paper entitled Unconstitutional Change Rooted in Peace Agreements, the issues I want to mention are threefold. Firstly, I want to talk about the challenge of unconstitutionality of peace agreements within the framework of an existing constitution. Secondly, I want to add some information about the constitutional replacement doctrine applied in Colombia by our constitutional court in the case of the peace agreement submitted by the government of Colombia and the FARC-EP. And thirdly, I would like to express some disagreement with some statements from Professors Tariq Olkay and Osalik Olkay in their paper. Well, regarding the first part of my comments, I want to congratulate Professors Tariq Olkay and Osalik Olkay for their presentation. I agree with their thesis about the challenge of unconstitutionality of peace agreements within the framework of an existing constitution. I also agree with the description of three strategies of shielding these peace agreements in transitional context. Firstly, recourse to international law. Secondly, adopting a transitional constitutionalism approach by high courts. And thirdly, attributes supraconstitutional or international legal status of a peace agreement. I also believe that it's true that these three strategies have some merit, but their effectiveness may be limited because they lack feasibility or political purchase. I think in Colombia, political willingness has been essential for the implementation of our peace agreement. Although many relevant points of our peace agreement were incorporated in our constitution through constitutional reforms, the reality is that a big part of legal developments took time to be implemented because of political factors. For instance, the peace agreement assigned 16 seats for victims in the Congress. In 2017, the bill that created these seats in the Congress collapsed before the Congress because of the lack of a majority. However, in a recent judgment from the Colombian Constitutional Court, this court revived the bill, and the current government of Colombia filed a request for invalidity of that judgment of the Constitutional Court. In a similar way, we have another example in Colombia. In 2018, the statutory law for the special jurisdiction for peace was objected by the current government, even though the Constitutional Court had already declared the constitutionality of the content of that law. Finally, the objections of the government were not accepted by the Congress and by the Constitutional Court. Therefore, I believe that Colombia is an evidence that strategies of shielding peace agreement in transitional contexts are not enough, mainly due to legal and political factors. Well, regarding the second part of my comments, I would like to talk about the case law of the Colombian Constitutional Court concerning the constitutional replacement doctrine in transitional context. Our Colombian Constitutional Court defended the peace as an axis of our constitution, also as a principle, right, duty, and a fundamental value. This court applied a flexible constitutional replacement doctrine to allow the incorporation of the peace agreement in the Constitution. However, in some judgments, it didn't have strong arguments and applied an intense constitutional replacement doctrine, ignoring the transitional context and the flexibility of constitutional principles. In judgment C-579, 2013, the Constitutional Court declared the constitutionality of a reform regarding the legal framework for peace, which provisionally contemplated the power of the legislator to establish criteria of selection and prioritizations to focus criminal investigation on those most responsible for international crimes. In this case, the court began to use the weighting test or the harmonization test in the control of constitutional reforms focused on implementing the peace agreement. The court established 3 parameters to assess whether a reform would replace essential principles of our constitution. Firstly, assessing whether the constitutional reform was focused on achieving peace. Secondly, checking if the reform introduced an element that could be replaced by a principle of the Constitution. And thirdly, harmonizing the 2 elements. In this judgment, the court weighs the peace, and the rights of the victims to justice, and concluded that the degree of detriment of the international state's duty to apply criminal law against human rights violations was not limitless. It was less important than satisfying the principle of achieving peace. Therefore, since this case, the Colombian Constitutional Court have begun to apply a flexible constitutional replacement doctrine to assess the constitutionality of reforms focused on implementing the peace agreement. Consequently, the traditional principles of a constitutional state must become flexible. This is to allow the transition from a state of war to a state of peace. In judgment C-132, 2017, our Constitutional Court incorporated an important element that should now be taken into account in the constitutional replacement doctrine, consisting of determining whether the constitutional reform affects the essential core of the constitutional principle. So partial reformulations that didn't violate the essential core principles have to overcome the constitutional replacement doctrine. This doctrine about a flexible constitutional replacement judgment was reiterated by our Constitutional Court in several cases. Nevertheless, this court did not always apply the constitutional replacement doctrine flexibly. For instance, in judgment C-332 and C-674, 2017, the court defended an authoritarian vision of constitutional principles, preventing a true weighting exercise in favor of peace. In the case of judgment C-332, our Constitutional Court declared unconstitutional the reform that described the faculty of the Congress to vote in block bills regarding the implementation of the peace agreement and the power of the government to authorize modification of these bills. In this case, the court considered that the reform had replaced the principle of separation of powers because the essential core of the legislative faculty was affected, especially the deliberative and decision-making capacity of our Congress. From my point of view, in this case, the court ignored that the design of the principle of separation of powers in Colombia is flexible. And this is for two reasons. Firstly, because in the case of government's endorsement for modification of bills deliberated at Congress, our Constitution authorizes them. For instance, in Internal Revenue Service, our Constitution authorized this government endorsement. Regarding voting in bloc, our Congress statute allows this faculty in any matter. Secondly, I believe that our Constitutional Court in this case did not consider the transitional context, which require giving greater weight to peace as a principle, duty, right, founding value of our Constitution, and as a necessary tool to exercise human rights. So the principle of separation of powers must be applied in a flexible way to allow the transition from a state of war to a state of peace. In addition, the court in the commented case did not take into account the essential core of the principle of separation of powers. The court did not take into account that the essential core of this principle was not affected by the constitutional reform because the Congress had the power to decide whether to approve or reject a bill or constitutional reform to implement the peace agreement. To conclude that point, the Constitutional Court ignored the flexibility of the principle of separation of powers in the commented case. On the other hand, in judgment C-674, the court declared unconstitutional the reform that prescribed the competence of the special jurisdiction for peace to prosecute and judge third civilians who had an active participation in the commission of international crimes in the armed conflict. The court considered that the aforementioned competence fully substituted the guarantee of natural justice because the special jurisdiction for peace is an ad hoc and ex post judicial body and was created based on different principles and structures from the one that guides the judicial branch. So the guarantees of independence, impartiality, and neutrality are different. In my view, I disagree with this judgment because the court, again, had an authoritarian vision of the guarantee of natural judge in this case. It is true that the constitutional reform affects this guarantee, but does not totally replace it. This is because, in accordance with Judgment C-200, 2002, the essential core of the guarantee of natural judge is the democratic creation of an impartial and independent judge who can prosecute third parties with the same guarantees that are applied in any criminal process, a characteristic that has the special jurisdiction for peace in Colombia. From my point of view, the Colombian Congress, a democratic organism, approved the constitutional reform that create the special jurisdiction for peace with its competence to prosecute and judge third civilians. Additionally, the special jurisdiction for peace preserves the purposes of the guarantee of natural justice. This is an independent and fair trial with full guarantees of due process. For example, many rules that regulates the special jurisdiction for peace in Colombia prescribes that all process carried out before this jurisdiction must respect the principles of impartiality, independence, and guarantees of due process. In consequence, I believe there is an impact of the guarantee of natural justice, but there is not an integral substitution of it, as the most relevant components of this guarantee continues operating. Furthermore, the mandatory investigation of third parties by the special jurisdiction for peace is a measure that contributes to achieving peace because it seeks to investigate, prosecute, and punish all people who participate in the armed conflict, not only those who negotiate the peace agreement. In accordance with a study carried out by the Justicia and Pax Holanda, the ordinary criminal justice system has not been efficient in prosecuting corporations that have played a decisive role in the armed conflict. The study illustrates that 12 years after the Justice and Peace Law, prosecutors collected material about participation of corporations in the armed conflict, and they forwarded 15,000 copies of cases to the prosecutor office. The report indicates that the status of this investigation request in most cases have not initiated an effective prosecution. To conclude this point, I believe the Colombian Constitutional Court in this case applied the guarantee of natural justice as a limitless principle, ignoring the transitional context and the elements or the essential core of such guarantee. Although the special jurisdiction for peace was not constituted prior to the commission of crimes, this jurisdiction was created by a democratic organ, the Congress, and enjoys the guarantees of independence and impartiality. Additionally, I believe that these changes of the constitutional replacement doctrine in Colombia, sometimes rigid, sometimes flexible, shows that this is a subjective and relative theory. It can change depending on the judge who participates in each judgment. Well, regarding the last part of my comments, I would like to express my disagreement with some statements regarding the scope of the constitutional replacement doctrine in Colombia and the amendment power in Colombia. Regarding the first point, on page 24 of the paper, it says that the Colombian Constitutional Court in Judgment C-332, 2017, regarding constitutional reform that created the fast track, held that principles of constitutional supremacy and deliberative democracy are unamendable. From my point of view, this is not accurate. I consider that our constitutional principles are amendable, all of them, because the Colombian constitution does not have stony clauses or intangible principles. In consequence, every article or principle can be reformed. What is forbidden is to substitute totally or partially a principle by another one, since the competence of the amendment power is just to modify the constitution, not to make a new one. The competence to create a new constitution is from the original constituent power. In this regard, the Constitutional Court of Colombia, in judgment C-551/2003, consider that one thing is that any article of our constitution can be reformed because our Colombian constitution did not include stony clauses or intangible principles. And another different thing is that under the excuse of reforming the constitution can be replaced by another that is totally different. In that case, the amendment power has exceeded its competence and became an original constituent power. In conclusion, I think that in Colombia, we do not have an amendable principles in our constitution. What is forbidden is to substitute such principles for others partially or totally opposing them. Well, regarding the last comment, concerning amendment power in Colombia, Professor Yannick Rosnay, who was cited in the paper, holds that when an amendment power is closer in process to popular constitution making and further from parliamentary amendment procedures, judicial review must be less intense. From my point of view, I disagree with this statement. I believe that in Colombia, we have had many cases in which, in spite of people participation in the amendment process, the judicial review has been the same. For instance, in judgment C-141/2010, the Colombian Constitutional Court declared unconstitutional the law that called a referendum where the people could decide if they agree with the presidential election for a third period. This process is more democratic than the common process to reform the constitution. The common process to reform the constitution in Colombia is through legislative acts. In this case, firstly, a group of people collect signatures. Then a spokesperson for that group of people presents the bill before the Congress. After that, the Congress deliberates and approves the law. Then the Constitutional Court decides the constitutionality of that law. And finally, the people vote in the referendum. Despite this democratic process with people participation in judgment of presidential election, the Colombian Constitutional Court, before the popular pronouncement, declared this law unconstitutional, as it allows the re-election for a third term, which is another opportunity for the president to nominate members of other public power branches that substitute the principle of separation of powers. This reform also substituted the principle of democracy because it affected the alternation in public power. In conclusion, I believe that judicial review must be the same, independently of people participation, because in some cases, the power of people could destroy elements of a democratic state. In this case, the separation of powers. Additionally, in Colombia was a public fact that if the people had been able to vote the referendum at that moment, the majority would have approved the presidential re-election. So I believe it's important to respect the constitutional limits, even with popular participation. Well, these are my comments. Thank you for your attention. I would be glad to answer any questions you may have. I don't know if Gonzalo wants that I explain this presentation in Spanish.
Muy brevemente, Fabio, porque el tiempo está limitado. Si puedes en unos 5 minutos más o menos contarnos y así dar oportunidad al público.
Ok, muy bien. Básicamente, mis comentarios se dividieron en 3 partes, ¿sí? La primera parte, el desafío de la constitucionalidad en la implementación de reformas constitucionales relacionadas con el acuerdo de paz, que es básicamente pues, la tesis de los profesores Tariq Olkey y Oselik Olkey. La segunda parte relacionada con la jurisprudencia de la Corte Constitucional colombiana acerca de la teoría de la sustitución de la Constitución en contextos transicionales. Y la tercera parte, algunos comentarios específicos que tenía sobre algunas afirmaciones en el texto de los profesores Tariq Olkey y Osalek Olkey. En relación con la primera parte, para decirlo de manera muy breve y no repetir exactamente lo que ya comenté en inglés, ahí explicaba cómo la tesis de los profesores es muy cierta, porque a pesar de que existen 3 estrategias para proteger los acuerdos de paz o para proteger, digamos, las reformas constitucionales encaminadas a la implementación de los acuerdos de paz, ellos hablan de acudir al derecho internacional o de adoptar un enfoque transicional por parte de las cortes, de las altas cortes, o de otorgarle un estatus supraconstitucional o de derecho internacional a los acuerdos de paz para protegerlos, ¿sí? A pesar de esas estrategias que ellos comentan en su escrito, no son suficientes, tienen problemas. En la práctica hay problemas políticos y hay problemas de orden legal, ¿sí? Entonces yo puse como ejemplo Colombia, en donde a pesar de todas las reformas constitucionales que se han dado para implementar el acuerdo de paz, en la práctica hemos tenido múltiples problemas políticos para lograr los desarrollos legales y para cumplir lo que dice la constitución política una vez reformada para implementar los acuerdos. Entonces puse el caso de las curules para las víctimas en el Congreso, que fue recientemente revivido por parte de la Corte Constitucional después de un problema acerca de las mayorías en el Congreso para aprobar esa ley. Puse el caso también de la ley estatutaria de la Jurisdicción Especial para la Paz, que fue objetada por el gobierno cuando ya había un pronunciamiento previo relacionado con la constitucionalidad y que finalmente las objeciones gubernamentales no fueron aceptadas. En la segunda parte del escrito, para decirlo muy brevemente y no extendernos, yo expliqué cómo la jurisprudencia que ha desarrollado la Corte Constitucional en Colombia en relación con la constitucionalidad de las reformas constitucionales encaminadas para implementar el acuerdo de paz. La Corte en unos casos ha explicado una teoría de la sustitución de la Constitución flexible, ¿sí? Y en otros casos ha explicado o ha desarrollado una teoría de la sustitución de la Constitución rígida, como si los principios constitucionales fueran absolutos, como si no admitieran una ponderación, en este caso, en favor de la paz. Entonces empecé explicando la sentencia C-579 de 2013, relacionada con el marco jurídico para la paz, donde fue declarada constitucional y la Corte explicó pues el test de ponderación o de armonización en favor de la paz, ¿sí? Y en ese caso ponderó por un lado la paz y por el otro lado la justicia y el deber de aplicar el derecho penal para sancionar a los responsables de crímenes internacionales, y la Corte le dio un mayor peso a la paz, ¿sí? Como principio, como derecho, como deber constitucional y como herramienta necesaria para el ejercicio de los demás derechos constitucionales. Esa tesis ha sido reiterada por la Corte Constitucional en múltiples sentencias. Sin embargo, en unas sentencias específicas que expliqué en la presentación, la C332 de 2017 y la C674 de 2017, la Corte defendió una visión absolutista de los principios constitucionales que estaban en juego. En el primer caso, una visión absolutista del principio de separación de poderes y autonomía del Congreso, para declarar inconstitucional la facultad del gobierno para autorizar modificaciones a los proyectos que cursaban en el Congreso relacionados con la implementación del acuerdo de paz y la facultad del Congreso para votar en bloque esos proyectos. ¿Sí? La Corte pues consideró que se vulneraba esa autonomía del Congreso, esa capacidad deliberativa, ¿sí? Y a mi juicio pues es una posición absolutista del principio, porque en la práctica el Congreso seguía teniendo la facultad para decir si aceptaba o no aceptaba la reforma o el proyecto que estaban sometiendo a su consideración. También cité el caso de la declaratoria de inconstitucionalidad de la competencia que otorgó un acto legislativo a la Jurisdicción Especial para la Paz para investigar y sancionar a los terceros que tuvieron una participación en el conflicto armado. La Corte consideró en ese caso que se sustituía la garantía del juez natural, y yo vuelvo a hacer la crítica, pues es una garantía, no es absoluta, ¿sí? Y en este caso no se eliminó por completo esa garantía. Esta reforma constitucional fue creada por el Congreso y respeta los elementos de independencia e imparcialidad en la medida en que la Jurisdicción Especial para la Paz también se encuentra obligada legal y constitucionalmente a cumplir con estas garantías. También indiqué cómo pues, esa reforma permitía la implementación del acuerdo de paz en atención a que la justicia ordinaria, según un estudio por de justicia, no ha sido eficaz en la investigación y sanción de los terceros que han participado en el conflicto armado. Y por último, ya en la tercera parte, expliqué un desacuerdo que tengo con algunas afirmaciones del paper de los profesores Tarek Olkey y Oselik Olkey, en una parte relacionado con el alcance de la teoría de la sustitución de la Constitución en Colombia, en donde citan en la sentencia C332 de 2017 y explican que los principios de supremacía constitucional y democracia deliberativa no son reformables. Expliqué cómo desde mi punto de vista todo principio constitucional sí es reformable, y lo que no se admite es que sobre pretexto de reformarlo se pueda cambiar o sustituir total o parcialmente por otro opuesto a ese principio, sustentado pues en jurisprudencia anterior de la Corte Constitucional. Y también hice referencia a la cita del profesor Yannick Rosnay, quien considera que en la medida en que el proceso de reforma constitucional tenga participación popular, sea más deliberativo, pues la intervención judicial debe ser menor. Yo puse de ejemplo el caso de la reelección en Colombia, donde a pesar de la participación popular en el proceso de recolección de firmas y la eventual participación que iba a tener el pueblo una vez pudieran votar la ley de referendo, aún así, pues el control de la teoría de la sustitución debería ser el mismo, ¿sí? Esto teniendo en cuenta que pues el pueblo también tiene unos límites previstos por la Constitución política, y que pues el pueblo tampoco puede sustituir elementos esenciales de la Constitución, tales como la separación de poderes, la alternancia en el poder público, entre otros a los que se hizo referencia en ese caso.
Bueno, muchas gracias. Thank you very much, Professor Fabio. So, if you want to say something, Tariq, and ask me about the comments of Fabio, and later we are going to have some question of the public. Here we have one. We are going to put in the panel also the people who if someone wants to do a question, just tell me, raising your hand in the Zoom application, and I will put you in the panel. Okay, so please, Ashley and Tariq, if you have some comments of the comments.
Thank you very much. Thank you very much, Fabio, for these comments. They were very informative and insightful. I've learned a lot about some of the decisions of the court. I just wanted to respond to two of your points, and then I'll let Tarek respond to the others. Firstly, about the issue of government change in Colombia. Obviously, I think the situation in Colombia in some ways shows the limitations of these strategies, of any legal or constitutional strategy when it comes to protecting peace agreements. When you have a new government which comes into power after an agreement is adopted, and a government that opposes the peace agreement, it is very hard to protect an agreement legally or constitutionally. And in almost all cases, the success of a peace agreement depends on political will. If the political will changes, then the legal means are quite insufficient. So you're very right about what's going on in Colombia. But I think there also the Constitutional Court is playing a role, and constitutional courts in general can play a role. If they are in favor of the peace agreement, obviously they can at least ensure the continuity of the required legal and constitutional reforms. So maybe there is a limited role for law and courts to play in protecting agreements. And then about your point on whether the Constitutional Court has been a bit strict, unnecessarily, unjustifiably strict, I think I agree with you. But this is a very sensitive area, I think, for courts. There are also quite a few Colombian scholars, for example, who think the court has been too lenient, whereas you think that the court has been too strict in some ways. So I think the court there tries to strike a balance between the supremacy of the Constitution and the need to implement the peace agreement. In certain respects, the court might have made errors, but it is a very difficult task, I think, and especially because the interpretation of these constitutional principles can be quite subjective and context dependent. So I think overall the court, as an external observer, to me, it seems like the court has done a good job overall, even though there have been issues in its case law. Over to you, Tarek, if you want to respond to the other points.
Sure, yeah. Thank you very much, Fabio, for your very, very helpful comments and criticisms of parts of our article. And I do take your points, although I want to respond to a couple of them. So your exposition of what happened throughout the court's reviews of various amendments was very helpful in setting the context. Of course, our article isn't simply a work on Colombia, but we look at patterns that emerge in different jurisdictions and try to tell a story and come up with how this challenge may be responded to. So that contextualization is very helpful, and we'll definitely take that use that when taking this forward when we're looking at Colombia again. And I will want to ask you whether you could give me the details of this case, the recent case that you referred to, where a judgment of the Constitutional Court was challenged itself, if I didn't misunderstand it, but we can talk about that later. So the other 2 points that I wanted to talk about are, first of all, the point about unamendability in Colombia. And yes, I mean, I would take your point there. Certainly, it's not strictly correct to say that certain principles are unamendable in the Colombian constitution, but we use the concept of the term of unamendability in the wider sense to include implicit unamendability, which is not strictly unamendability like in India. The basic structure doctrine is considered to be unamendability, but certainly there's nothing in the Indian constitutional text that says that any of those principles are unamendable. It's read into the constitution, and if an amendment has been made that makes that constitution's coherence or puts that at risk, then that might be invalidated. So in that sense, it may be unamendable because the court will say that you can't make that amendment because that amounts to replacing the constitution, not that there are certain unamendable things in the constitution, because even when there's an explicit unamendable provision, it doesn't really mean that it is not amendable in any case. Some people call it a constitutional revolution. Some people call it an extra constitutional amendment, or some people call it constitutional dismemberment, and it can succeed. But it was helpful to hear your points, because there is nothing stopping us from describing or presenting the Colombian case even more accurately. So perhaps we'll refrain from using the word unamendable and simply refer to substitution or replacement in our later work. So thanks for pointing that out. And my second point is in response to this idea that we borrowed from Yaniv Roznai about the judicial involvement and so this idea of spectrum of amendment powers and how judicial review power may be directly proportionate with that, or well, inverse, yeah, in a way. There, I think I would still disagree with you, not because what you explained is wrong or inaccurate, but I think what this thinking does is to help alleviate some of the disadvantages of the transitionalist judicial review type of strategy, where we talk about perhaps the Constitutional Court being afraid to politically align itself with a certain party, say, who have been to date considered as terrorists, for example, or with the government, and they may give the perception that they are actually not, they don't have judicial independence, or they might not be willing to take the political risks. They may not want to be the ones that actually make the ultimate decision as to whether this peace process has been successful or not. And if there is some level of participation, more than just a vote in a parliament or just a governmental and executive decree, I think we can talk about some difference between some level of engagement, some level of participation, some level of inclusivity, and none whatsoever. Even if people might argue that that was just for show, or that wasn't really inclusive, I think there might be that psychological effect on courts where there is some level of participation. I'm not suggesting that the context is irrelevant. This may work in some contexts. This is just an idea that may be applied to transitional settings, but I think this may be a consideration. But I certainly, so Yaniv Roznai in his book presents this as a general theory. So he thinks that the more participatory a constitutional amendment process is, and by participatory he means tools like referendum, the less strong judicial review should be. We wouldn't go as far to put this forward as a general theory of how we should understand judicial involvement in reviewing constitutional amendments rooted in peace agreements. But we're simply pointing out a way to look at it, and if all other things equal, this may be a consideration, because that may, first of all, encourage courts to step in a constructive way, but it can also mean that various interests have been considered during, at least to a certain extent, during the process. I don't know if that makes any sense.
Thank you very much, Tariq and Ashley. Voy a traducir un poquito, bueno, sobre los comentarios de Fabio, que pues muy acertados, y sobre lo que puede ser también la experiencia colombiana, y sobre algunas de las críticas que dio sobre el paper, pues por ejemplo sobre la idea de la primera idea, digamos, sobre si el control debe ser menos rígido, más rígido, cuando se encuentra, digamos, el principio de la paz de por medio, Ashley le responde a Fabio que hay discusión, ¿no? Sobre esto, no hay una sola línea. De pronto Fabio pues dice que tiene que ser más flexible cuando se, pues, cuando se introduce el principio de la paz, pero hay otros estudiosos que han dicho que no, que la Corte ha sido muy, en este caso no ha sido tan exigente cuando revisa los acuerdos de paz y el control de constitucionalidad de sus reformas. Entonces en eso, digamos que dice que la Corte pues actuó de una manera, podríamos decir, ponderada. Meto la cucharada, habría que ver un poco las decisiones sobre la JEP, ¿no? Que fue tan criticada y que Fabio nombró principalmente, donde declara inconstitucional la participación de terceros y de militares. Pero bueno, sobre el otro punto, ¿no? Tarik le da la razón a Fabio sobre, sobre digamos, de decir en el paper que son inmodificables los principios, porque pues así no lo ha dicho la Corte, ¿no? Entonces, sino cuando se cambian o derogan principios, pero no quiere decir que sean inmodificables, no son cláusulas pétreas. Y luego sobre el otro punto de quizás que trabajaron allí, digamos que discutieron sobre la tesis de Yannick Frosnay de que a mayor participación popular menor debe ser digamos, la rigidez del control de constitucionalidad, que es una tesis que se viene desarrollando en Colombia también desde una sentencia donde fue magistrado Rodrigo Primi, en donde él dio esta idea de que si el mecanismo de reforma constitucional tiene mayor participación, pensemos en referendo constitucional, el control de constitucionalidad debe ser menos rígido cuando se trata de reformas constitucionales. Digamos que esto es una tesis de Yanip que simplemente expusieron en el paper y no quiere decir que se está de acuerdo con esa tesis. Entonces vamos a dar oportunidad, digamos, a los participantes. Tenemos aquí a Diana Isabel Guisa, que está en Estados Unidos también haciendo su PhD. Here is Diana Isabel Guisa, who is also doing his PhD research in the United States. Where are you working, Diana? Hi.
Hello, I am in Bogota right now.
Okay, so you are in Bogota. But where are you studying right now?
Well, I'm studying constitution making and peace building, which is a topic related to the paper that you already presented, and the political economy of peace building in contemporary.
In which university?
The University of Notre Dame.
Okay, in the United States. So thank you very much for being here. We are going to invite you also for this seminar. It will be a pleasure, and also to have the seminar in English. It will be fine to other people who doesn't speak Spanish. So please make the question and the comment if you want.
Thank you, Gonzalo. And thank you so much, Ashley and Tarik, for your presentation. I haven't read your paper yet, so I apologize if I am raising a question that is already answered on your paper. But at least after listening to your presentation, I would like to hear more about the interplay of constitution making and popular endorsement and peace building in transitional societies, and particularly in the case of Colombia, constitutional amendments and popular endorsement after the signing of a peace agreement. Because I have some theoretical and empirical questions, and I will just frame some of them to situate my question on this topic. As you already mentioned in your presentation, constitution making and popular endorsement are used to ensure compliance and sustainability, as both post-conflict constitutionalism and popular ratification are trying to sort of transform the initial peace elite deal into long-lasting normative commitments and a stable, broad-based participatory political system. However, theoretically, we can see, and borrowing from Elster on his distinction on essential and incidental constraints, that constitutional amendments that are enacted after the signing of a peace agreement, they may suffer from a sort of lack of inclusivity or inclusiveness. So given that after the signing of a peace agreement, we are so concerned with compliance and how we can lock out peace commitments for generations to come, the framers have no word on the signing of a peace agreement. Indeed, they are left aside at the peace table and during the peace process. So peace processes are inherently elite scenarios in which only the warring parties, and in this case, the Colombian government and the FARC-EP, are writing down commitments, even if the peace table is open up to hear certain social and political groups' concerns, such as victims. So I wonder if you have reflected upon this theoretical relationship, how inclusive constitutional amendments are that are at the end enshrining peace commitments that were drawn by the signatories outside of a constituent assembly or any sort of constitution making processes. So that question is more theoretical. And about the Colombian process, how you see that constitution making and constitutional amendments are framed after the rejection of the peace agreement on the plebiscite on October 2nd, 2016, even though it was a revisited agreement that was approved by Congress, and it was deemed a sort of popular endorsement, even though it wasn't direct citizen involvement. How do you see that despite such drawback, in the Colombian case, we can see a sort of relationship between constitution making or constitutional amendments and direct citizen involvement? Thank you.
Gracias, Diana. ¿Puedes traducir un poco la pregunta brevemente?
Sí. No, simplemente quería saber un poco sobre las relaciones entre cambios constitucionales y participación política o ratificación popular, como lo llamamos en su momento este proceso en Colombia, y procesos de paz. Porque teóricamente uno podría decir, yo aquí siguiendo un poco a Elster, cuando él hace la distinción entre límites como esenciales y externos, cambios constitucionales, específicamente reformas constitucionales después de un acuerdo de paz, pues no parecerían tan democráticas, porque la escritura de esos acuerdos de paz y esos compromisos queda en manos de las partes, en el caso colombiano del gobierno nacional y de las FARC-EP, y con la idea de poder asegurar el cumplimiento de esos compromisos para las siguientes generaciones, pues queda muy limitada la capacidad de cambiar esas reformas en el Congreso, en este caso. Entonces, mi pregunta es, teóricamente, ¿uno cómo puede entender esas reformas a la Constitución que derivan de acuerdos de paz? ¿Qué tan democráticas o qué tan incluyentes pueden ser? Y en el caso colombiano, quisiera saber cómo Ashley y Tariq ven esa relación entre cambio constitucional, en este caso específico reformas, y inclusión o participación directa de los ciudadanos en esos cambios.
Okay, thank you. Please, Tariq, Ashley, you want to answer?
Thank you. Thank you very much, Isabel, for joining us and for this question and for bringing up the very important issue of inclusivity. It's a very important issue both in peacemaking and in constitution making. This is not something that we look at length in the paper. It does come up in certain parts of the paper, but this is also an opportunity for us to expand on our views on the issue of inclusivity. I think this is one of the key dilemmas of peacemaking and of transitional justice. It is a bit like the peace versus justice debate. So this is perhaps the, pragmatic requirements of peacemaking versus inclusivity dilemma. I mean, inclusivity, achieving inclusivity is quite important, you're right, and it is right that peace deals are often concluded by warring parties. They are elite deals, and this is an issue that is discussed quite a lot in the scholarship. The problem here is how much inclusivity can you achieve when at the end of the day you need the warring parties to stop fighting and sign a peace agreement. That's the reality of peace processes. And obviously, I mean, in Colombia, for example, the peace agreement went through a relatively inclusive negotiation process. At the end of the day, I think all peace agreements are bound to be elite deals because they're signed by the warring parties. But the process can be more inclusive. And I think in Colombia, there was significant effort in this respect, and the process was praised internationally. I'm sure there were, and I think that there were weaknesses, but victims were included during the negotiation of the Transitional Justice Agreement. Broader societal groups were included at different points of the negotiation. There was a plebiscite, and obviously the odd point is that the agreement was rejected at the plebiscite, but then was revised and then approved by the Congress. But there is, I mean, especially compared to many other peacemaking contexts, there was a significant degree of democratic accountability and also judicial accountability in the Colombian process. The Congress adopted a series of laws throughout the negotiations and then eventually approved the peace agreement. Yes, it was through the fast track process, and there are problems with that. But then also the Constitutional Court was also always involved in the process and oversaw the constitutionality of the agreement, even though it adopted more lenient approaches when it was reviewing these amendments and laws. But I think, as I said, the Colombian case was relatively more inclusive and democratic. The problem with peace agreements is that if you try to ensure democratic accountability after the agreement is adopted, you risk undoing the agreement. So if you give parliaments more power, if you give courts more power, when it comes to adopting the agreement into domestic law, then you risk the agreement being undone and then the fighting to restart. And this has happened in some countries. In the Philippines, for example, in 2008, they achieved a ceasefire. They prepared a peace agreement, but they couldn't sign the agreement because the Supreme Court found it unconstitutional in many ways. Immediately after the court's decision, the conflict re-erupted, and then for 6 years, they couldn't achieve another peace agreement. So courts and these post-agreement accountability mechanisms can have significant adverse effects. I think the most effective solution there is to make the negotiation process itself more inclusive, opening it up to broader societal groups at the point of negotiation. But I think at the end of the day, there has to be a degree of pragmatism in peace processes and an acceptance that the consent of the warring parties is what matters eventually. Yeah, I think, I mean, it's a difficult area. It's a tricky issue. So I think making the processes more inclusive is the interim solution. And the ideal scenario would also be if the post-agreement processes are more democratic. If, for example, an environment of peace, democracy, and reconciliation is achieved after the agreement, and within that environment, instead of fighting, if parties and also the different groups in the society can use the democratic channels to then change the constitution in a way that also departs from the peace agreement. This was, for example, the aim in Bosnia, but the agreement in Bosnia was concluded in 1995. It's been decades since then, and they are still locked within the elite structures of the agreement. So it's quite hard, even in the post-agreement peaceful process, to move on from the peace agreement. So I agree with you that there is a significant challenge there.
Bueno, I don't know if Tariq want to say something or.
I had just a very brief point that, well, maybe 2 points. That if we have time, do we have time?
We have.
Okay. So the first is that I mean, I'm more of a constitutional lawyer than an international lawyer, and I have been more interested in constitution-making processes without a transitional justice context and constitutional amendment processes as well. And what strikes me in this sort of debate is that it's not only in transitional settings where it's the elites that make these decisions, but also in any constitutional, well, not any, but in many constitutional change processes. And some are more participatory than others, but as Asli was explaining, usually the decision-making is down to either political elites or military elites in certain countries. And I don't know how much Asli would agree with me on this, but I would be more pragmatic in terms of achieving, especially in the sense of achieving peace. If the cost is to have a less participatory process, as long as that's achieved. But that's not to say that that's a general rule that I would try to apply to each and every context. But I think that the point we made, that Fabio actually criticized about how we used Yanni Vrosnay's point about participatory processes and how that speaks to judicial review of amendments rooted in peace agreements. I think the point there is that participation can be recognized, the value of participation can be recognized by seeing it, even if it's only window dressing or not really representative of what a proper participatory process looked like. There may be a recognition of the value of participation compared to no participation at all, in the courts being a bit more lenient in terms of what's being done, even if that is on its face violating the current constitution or a constitutional principle, and that might sort of give certain tools to courts to use that participatory justification for what looks like a violation of the constitution to be accommodated within the existing constitutional order. But otherwise, I think the point about inclusivity is a very difficult problem, especially in constitution making contexts. Certainly in divided societies, we know there's the successful example of Iceland, but it's very difficult to compare divided societies. I mean, we have the experience of Turkish constitution making, because that's where we did our law degrees, that's where we're from. We're familiar with how constitution making works or doesn't work in deeply divided societies, and it can be a valuable exercise in itself, the participation process where it's inclusive. And that was the experience of Turkey back in 2011. There was a constitution-making body that was created to write a new constitution, which would be a civil constitution after the two successive military written constitutions. And that process failed miserably, although it started as a very genuine, participatory, inclusive process, which spent time. There was a committee, ad hoc committee set up that listened to all parts of society without prejudice for months. And then I'm not going to say the suggestions were largely ignored, but they weren't seriously taken into account in the drafting. And eventually the process failed in any case, because again the process was built in a way that would the rules of the committee was made in a way that would make it very difficult for for the political parties to come up with a workable draft that they would all agree on. So I think there is an argument there about being a bit pragmatic without necessarily excluding large parts of society. But I think focusing too much on the inclusivity points, especially in conflict settings, I think it's more important, may be counterproductive, and inclusivity or inclusivity considerations perhaps may be deferred to after after peace is achieved, and that those considerations, representation, and things like that may be again discussed within the context of that peace. I don't know. I mean, these are all general points which may be completely irrelevant to many contexts, but at least it might explain where I'm coming from in terms of what I understand where inclusivity should be in all this, especially from the perspective of constitution making or making fundamental constitutional changes to an existing constitution.
Thank you very much. Gracias. Pues más o menos le dijeron a Diana que Ashley le dice que sí, esto es un punto muy importante, digamos, la participación ciudadana, que sean los procesos, digamos, de reforma, pero la revisión y todo esto inclusivos para que haya participación ciudadana, pero que es algo que puede ser riesgoso, ¿no? Que es lo que vimos acá cuando las cortes constitucionales, como en el caso de Filipinas en el 2008, la Corte Suprema declaró inconstitucional una reforma constitucional para la paz. Entonces esto puede ser riesgoso y se necesita tomar, no sé, pues también hay ideas pragmáticas para que se puedan desarrollar o implementar estos acuerdos de paz a través de reformas constitucionales o leyes, pero a través de reformas constitucionales y evitar, ¿no?, que se hagan modificaciones en el Congreso. Bueno, que esto es una tarea difícil, ¿no? Podríamos decir que lo que ella recomienda es hacer procedimientos, digamos, que el proceso de paz sea inclusivo, es decir, cuando se hagan los diálogos y esto, pero también es difícil, ¿no? Tariq nos dice pues que él más desde el punto de vista no de solamente las reformas constitucionales para la paz o en justicia transicional, sino en cualquier otro ámbito también puede llegar a ser difícil esto que llamamos, digamos, incluir a las personas, la democracia inclusiva o incluyente o la democracia participativa, que está el caso de Islandia, que es un caso paradigmático, en donde todo el mundo habla, ¿no?, de una propuesta de hacer una nueva constitución, donde se hicieron varias propuestas novedosas, como los mini publics o los sortition, todo esto, redes sociales, pero finalmente no concluyó en nada esta reforma, este cambio de constitución, pero sí es un punto importante. Podríamos concluir que hacer la participación ciudadana, digamos, es muy importante, y la democracia deliberativa para poder llegar a buen puerto en reformas constitucionales y aún más pues en reformas constitucionales para la paz. Que el punto de Yanip, digamos, se lo tomaron en cuenta, sí, nuevamente, ¿no?, de mayor participación, menor control o menor rigidez del control, ¿no?, como un punto, digamos, de apoyo de su artículo. Habría que mirarlo. Bueno, estamos también con Juan Fernando. We are also with Juan Fernando, who is also he's also doing his PhD in Peru right now, and he is also a very friend of mine. He always come to the seminar. Very interested in the Congress, no, in corruption. He's working in this topic in Peru right now. So thank you, Juan Fernando, for being here. Please make your question.
Okay, thank you, Gonzalo. First of all, congratulations for organizing this meeting and for all the presentations. Let me tell you that I was part of the team negotiating the peace agreement in the Havana. So I worked very closely with them, and I have a more internal perspective of what we try to achieve and the problems that we have. And one of the problems that we have, and this is my question, is that the government negotiated with the guerrilla, but then we have to go to Congress to pass the constitutional amendments needed for make the peace agreement real. And actually, and Fabio mentioned this, we have a couple of agreements that are still on the process, like the 16 curules, 16 seats for victims in the Congress. So my question is related to the issue of the separations of power and peace agreement, because the branch who made the deal is the executive branch, but the other branch who is in charge of really introducing the changes in the constitutions in the Congress. And we have also the constitutionally review that you mentioned. But right now, my concern is about the relation between Congress and government, because we still have a problem with the ELN in Colombia. That's the guerrilla that wasn't part of the agreement, the National Liberation Army, and we probably need to make another peace agreement with them. But my concern right now is how we can tell them that we're going to fulfill the agreement if in the past we fail to fulfill the agreement with the FARC completely. That's my main concern right now. So what are your thoughts about this relation between Congress, majorities in the Congress, and the executive branch, not the constitutionality review of the process? Thank you.
Thank you very much, Juan Fernando. So I'm sorry. So this is the last question. So Ashley, Tariq, and also Fabio, please answer the question. And if
Yeah, thank you very much for joining us. It's great to have someone who has the inside information about the negotiations. I think this problem is more important in contexts like Colombia, the separation of powers and the oversight of the parliament, because in Colombia you have a peace process, actually various peace processes with different armed groups, but also a very strong and established legal system that has a very strong parliament, the Congress, also a very strong constitutional court. And the society itself is quite legalized in a way. I mean, I was astonished during the negotiations that there were, programs about the peace agreement during the prime time on televisions, and everyone was following these debates. This is not the case in all contexts. In the presentation, we mentioned other examples, for example, where the negotiating parties were able to introduce provisions in the peace agreement that would automatically change the constitution. So, for example, in Rwanda, they did this, and they didn't need to go through a parliamentary approval process. They didn't go through constitutional review processes. So in those contexts, it's easier to implement peace agreements because there is less democratic accountability outside of the peace agreement. But this is not the case in Colombia. This wasn't the case in the Philippines either. For example, there as well, the parliamentary oversight was quite strong. The Supreme Court is quite activist and is very much involved, and also enjoys a significant degree of legitimacy, like the Colombian Constitutional Court. I think in these contexts, at the end of the day, it boils down to political will. If you have during the negotiations, there was a government that was willing to bring the negotiations to an end with an agreement and willing to implement the agreement. Right now, that's not the case. As far as I know, we have a government now that is not in favor of negotiated agreements with armed groups to the same extent. I think the timing is quite important to make sure that these agreements are achieved when there is political will to implement them, and to make sure also that the governments who are negotiating these agreements have a democratic mandate from the Congress. Because in Colombia, I don't think there is any way that the Congress or the Colombian Constitutional Court can be circumvented. They are always going to be involved. So it's important to have that democratic mandate. I'm not sure if the plebiscite was a wise idea, was a feasible strategy. I see the benefits of that, the approval, the seal of democratic approval, but it didn't happen, so it backfired in a way. I mean, there is a lot of scholarship that suggests that referenda are not a good idea when it comes to peace agreements, and it should just go through the regular democratic channels, you know, just the Congress without the referendum.
Learn that lesson.
Yeah.
The hard way.
I know. So yeah, I mean, there's no straightforward answer, I'm afraid, that I can think of, but it's I think it's to do with a mandate from the Congress, clear mandate, maybe a framework law at the beginning of the negotiations, which you did. I mean, Colombia did all of these things. I don't know if Tarek wants to add something.
Not much, really. I really agree with all that you say, and perhaps it's also interesting to realize that this is actually very similar to the debate that we've had in the UK about Brexit. Theresa May got a deal with the European Union, but her MPs in the UK Parliament didn't like that debate. It was awful. It was a very difficult process, but obviously there was no conflict. And I think, although this is a general problem with the executive having the power to enter into agreements, international agreements, although the peace agreement was different in legal status, I think in the context of peacemaking, I think the legal structures may be interpreted in a more lenient way. Otherwise, we see what we see, and things like referendums being the defining points of these processes, hard achieved deals just disappearing because of a small margin of voters, rather than making decisions during a process, just making a decision on a single day, saying yes or no, a very simple answer to a very difficult question, voting a whole package by saying yes or no. And so I do agree that referendums, in many countries, we are seeing referendums and then neither party being really happy with the overall results and the problems still being there. So but that I suppose is at the center of the challenge, because it also this whole way in which these things work also gives weaponizers, domestic actors who are against a peace deal on those terms, to challenge the government also in a political way, to bring them down, because they also don't want them to be in government, but they also don't want the peace deal. And I think it creates fragility on the part of the government when negotiating with groups that are party to the conflict. I'm not suggesting any solutions, obviously, to this problem, but I think perhaps the central theme of our article is that the existing constitutional structures must be taken seriously, because it affects all these processes. The separation of powers is part of the Constitution, and if we just simply ignore that, it will come up later on. So when parties are negotiating these things, I think it's crucial that they keep thinking about these existing constitutional frameworks and not just think that they're not important anymore because we're in a constituent process and we'll create a new order and they won't matter, because that's not guaranteed. Sometimes it happens, sometimes it moves on rather flawlessly, but usually the existing frameworks are voiced by certain people who are either unhappy with the peace deal or simply want to overthrow the government. And I think thinking about these things during a peace process, taking the constitutional framework seriously, may help achieve a more, sort of sturdier peace deals.
Thank you, Tariq. Fabio?
Well, I agree with Professors Tariq Olkey and Osalik Olkey regarding this question. I also believe that it's important to take into account the political willingness. I believe that in every peace process around the world, the political problem or the political willingness must be taken into account in every peace process. As happened in Colombia, maybe our government in that moment didn't take into account this problem, and the political willingness has been essential for the implementation of every peace agreement. In our case, although we have a lot of constitutional reforms, although we had a lot of strategies of shielding the peace agreement, we try to attribute international legal status of our peace agreement. We try to attribute that our peace agreement is a special agreement from the point of view of the international humanitarian law. But in spite of these strategies, the political problem is real. Sometimes the people in general, the current government, the congressmen, sometimes they are not agreed with the peace agreement. So it's important to take into account the political willingness in every peace process. I have 2 more comments. I don't know if we have time or you want to finish right now.
You have 1 minute.
Well, I just want to finish my comments talking about the judicial review in the case of the thesis of Professor Janif Rosnay. I believe that it's important that the judicial review must be the same in every case, independently the popular participation. Why? Because sometimes the original constituent power can destroy international essential principles that are very important. For example, if our people want to revive the death penalty, or if our people want to violate the international convention to protect human rights, the American Convention of Human Rights, I believe that through the constitutional replacement doctrine, it's important to put a limit of such power because we have to protect international values, international human rights, international treaties, and we have to protect the political power. For example, in the case of the presidential re-election, our constitutional court protected in that moment the principle of separation of powers, because allows the presidential re-election for a 3rd term is another opportunity for the president to nominate members of other public power branches, which substitute the principle of separation of powers and the democracy, because it affects the alternation in public power. So I believe it's important to have the same judicial review, even with popular participation. I know this is a very polemic or problematic thesis, but I believe this is important to protect the limits that provide the international law, the international human rights law. On the other hand, to finish, I just want to mention that the constitutional replacement doctrine overall is relative and subjective. As I told you before, in the case of the principle of separation of powers and the guarantee of natural justice, our constitutional court applied a very strong constitutional replacement doctrine without convincing arguments. And I think that it shows that this theory sometimes can change depending on the judge in the specific case. Sometimes for a specific judge is more important the principle of separation of powers, and sometimes for other judge is most important the peace as a value, right, duty of our constitution. Or for example, in the case of the mandatory investigation for third parties by the special jurisdiction for peace, in that case, for the judge was most important this guarantee than achieving peace. So I believe that this is one of the problems of this doctrine, that sometimes it is relative and subjective. So that's it. Thank you.
Thank you very much. Bueno, voy a terminar. Bueno, Juan Fernando preguntó sobre la separación de poderes, nos recordó que también él trabajó en el proceso de paz en La Habana, ¿no? En los diálogos de La Habana, y lo difícil era llegar al acuerdo, pero después convencer también al Congreso y bueno, en parte a la Corte para que esos acuerdos llegaran a buen puerto y se implementaran, ¿no? Y el temor ahora es si se van a hacer unas nuevas negociaciones con otras guerrillas, por ejemplo el ELN, pues hay algunas partes del acuerdo de paz con las FARC que no se han cumplido, como el ejemplo de las 16 curules para la paz que finalmente pues hasta ahora están siendo aprobadas por vía tutela en un procedimiento legislativo por el conteo de unos votos, pero digamos existe aún el temor de que los otros poderes puedan llegar de alguna manera a entrabar estas negociaciones tan difíciles. Entonces la pregunta de Juan era sobre la separación de poderes en esto, y digamos que la respuesta de Ashley y Tariq también tienen que ver un poco con el derecho constitucional comparado. Ashley un poco sobre una idea también pragmática, diría yo, de buscar una salida, ¿no? Finalmente ella nos ha puesto de presente algunos casos, ¿no? Como Filipinas, y que la Corte Suprema no aprobó pero otros casos donde hay, digamos, las reformas constitucionales en Filipinas, pero otros casos en Ruanda, por ejemplo, en donde se impusieron reformas constitucionales como de sin discusión alguna. Ella valora un poco lo que se hizo en Colombia, a pesar del plebiscito, ¿no? Que lo pone en duda como una estrategia que ahora piensa que no fue una buena forma, digamos, de implementar finalmente al menos el acto legislativo que posibilitaba la vía rápida, ¿no? El fast track. Pero bueno, y Juana hizo una intervención, bueno, que es una lección aprendida, ¿no? Pero bueno, lo último era Tariq, otra vez, desde el derecho constitucional comparado, hace una reflexión muy importante, y es, mire, eso se me parece mucho al Brexit acá en Inglaterra, y es cuando finalmente el gobierno puede negociar algo, ¿no? Y se lo somete a referendo, como un tratado internacional sometido a referendo, ¿no? Como someter el acuerdo que hicimos con la Unión Europea a referendo, y esto puede ser muy peligroso, porque puede llegar a que se someta, digamos, pues todo un acuerdo muy difícil de llegar después de muchos años, ¿no? Que la Inglaterra hiciera parte de la Unión Europea simplemente un sí o un no. Entonces, como que finalmente también Fabio destaca varios puntos sobre lo que se discutió, y principalmente, bueno, en uno de sus comentarios finales, la tesis de Yannick Frosnay. Él cree que no está de acuerdo con esa tesis. Finalmente, él cree que el control constitucional de las reformas constitucionales debe ser igual en todos los casos, y también cuestiona la idea de que en algunas decisiones de la Corte Constitucional que él ya estableció, por ejemplo, pues en el de la JEP o en otra, como en la C674 del 17, la decisión sobre la JEP, cómo se dejó por fuera a terceros y a militares, y cómo y también, digamos, algunas sentencias de inconstitucionalidad por sustitución, en donde se valoran unos principios de mayor forma que otros principios. Esa subjetividad y discrecionalidad de los principios cuando se ponderan, ¿no? No, como que todavía no se ha llegado a que la Corte Constitucional siga un precedente estricto para tratar de buscar cómo la subjetividad y discrecionalidad del juez no se inmiscuya. Yo creo que, bueno, esto más o menos es lo que dijeron los profesores y los comentarios. Y les quería agradecer. I want to thank everybody, especially Tariq and Ashley, Professor Fabio also for the good presentation. Your paper also is very important for us in comparative perspective. I think the comparative perspective is very useful for us in Colombia. We are not used to use the comparative constitutional perspective. Many of our scholars didn't work in that field. We try, no, but we are not an expert in comparative constitutional law, and we need to focus in other contexts, also in other experience, to learn about, to compare, and to also know that our domestic case is not is not unique, no. And I think that is the richness of the constitutional comparative law perspective. That's why we invite you. That's why we are going to also have more conversation with you and more relationship with you both in Scotland. I think this is very nice to have the change of the ideas this soon. Is fantastic to do so. So we are going to have more conversation, more exchange of ideas. Thank you very much for the three of you. I don't know if you want to say something.
I just want to thank you very much again, Gonzalo, for organizing this, for inviting, for your feedback on our paper before this event as well. Thanks to also Professor Fabio for his comments and for all the questions. It was really a privilege to be here and to talk to you today about the Colombian experience, but also the comparative experiences. You're right, Gonzalo. Transitional countries often think that their problems are unique and very dire. They are dire, but they are definitely not unique. They are experienced across many jurisdictions. And it is very important to, I think, have these conversations about different experiences. So thanks very much. I hope to stay in touch and continue the conversation in the future as well, because we'll be working on this topic and on Colombia as well.
And Tariq.
Yeah, not much to add. Thank you all very much. Thank you, Gonzalo, for organizing this, and for Fabio for your wonderful comments. They'll be very helpful for us when we're thinking forward in terms of this project, and also to Senor Juan Fernando Londono. It was very nice to have you here, and thank you for your question. It certainly makes you think about the challenges that the actual negotiators face. We simply talk about the legal frameworks, but the actual work is done during the negotiations. So it was nice to have you here as well. So thank you very much for taking the time to join us, and thank you all for taking the time to be here. It's been what, 2.5 hours almost.
Almost.
Yeah, so we really appreciate it.
Yes, the last word for Fabio.
Well, thank you very much, everyone. Thank you very much, Gonzalo Ramirez, for inviting me to this seminar. I really like this topic. It was a privilege to be here with Professors Oselik Olke and Tariq Olke. We are thinking to translate your paper. We can continue talking about your paper because we want to translate it. So I think this is a very good idea. Thank you for everything. Have a good night in this moment in Scotland.
Yes, yeah.
Thank you so much. That's an amazing
Thank you.
idea. And thank you, Gonzalo, for translating everything into Spanish during this event. We really appreciate it.
It was
Yes,
very bad.
I
Very
didn't
bad
expect
translation,
that, so,
but
yeah, no,
it was a
thank you
very
very
bad
much.
translation.
Yeah.
I add many things that you didn't say, but unlimited things that I want. No, thank you very much. I'm going to. I asked Fabio. To do me a favor to translate your paper and publish in our journal, no, in Revista Derecho del Estado. It will be a pleasure if you have all the permission. If we have all the permission and all the things to translate the paper, that it will be wonderful to have it the paper also in Spanish. So it's an idea, and we are going to do so. Pues bueno, muchas gracias a los tres, a Fabio, a Ashley, a Tariq, a Juan Fernando, a Diana, a Manuela Lozada, por este seminario. Duró bastante, pero bueno, por las traducciones y todo esto. Entonces, fue bastante enriquecedor. La invitación es para hacer más derecho constitucional comparado, ¿no? Nosotros creemos que el derecho constitucional colombiano e incluso pues latinoamericano, los países europeos y Estados Unidos son los únicos, pero hay que leer más derecho constitucional comparado, hacer más derecho constitucional comparado. Los profesores Tariq y Ashley están haciendo ese esfuerzo. Países como Irak, países como Ruanda, países como Bosnia, todos los países que han tenido experiencias, Filipinas, Turquía, para poder nosotros entender los problemas de una manera, digamos, también mucho más amplia. Entonces, es importante tener esta perspectiva. No hacemos mucho derecho constitucional comparado aquí, hay que hacerlo y ponernos también en el nivel de los profesores que lo están haciendo también. De nuevo, gracias a la Universidad Externada de Colombia, al Departamento de Derecho Constitucional. Thank you a la Universidad Externada de Colombia, Constitutional Department de la universidad, y a la Universidad de Glasgow y a Dundee University en Escocia por este evento, y a todos los participantes. Nos vemos para la próxima. Thank you very much.
Thank you.
Thank you very much. Goodbye.
Goodbye.